Hi, my name is Wayne Pierce. I'm Executive Director here at the Equity Center in Austin, Texas. We're an organization that represents nearly 700 public school districts around the state in school finance matters. And today we're here with our guest, Rick Gray, who is the lead attorney with the Texas Taxpayer and Student Fairness Coalition that was involved in the recent school finance litigation. And we came today to kind of get an overview of what happened and answer some questions.
Thank you. It's nice to be here.
Good to have you here. Kind of dismal, the result, not exactly the one that we wanted.
No, not at all. I mean, it was extremely disappointing. We knew that it was potentially an uphill fight, but the oral argument at the Supreme Court, we thought, and by we, I mean all the lawyers thought it went very well. I think the state thought it went very well for our side. I think the press thought it went well. But unfortunately, the Supreme Court came down with a decision that was very, very disappointing.
And disappointing for lots of people, judging by the editorials around the state.
Yeah, the editorials have gone crazy against the opinion. And the reality is, we let down over 5 million school kids. I mean, the system is hopelessly broken, and this Supreme Court, in their opinion and in the two concurring opinions, made that clear. I mean, they've called for a systemic change, a top-to-bottom redo of the system. They've said that a Band-Aid on a Band-Aid on a Band-Aid will no longer suffice. They acknowledged all of the pitfalls and problems and lack of equity and lack of fairness and lack of adequacy that we presented in the case, and Judge John Dietz found in his very, very extensive opinion. But they then went on to hold that it's minimally constitutional. Like I say, it was one that was exceedingly disappointing.
The group that you representing, by the way, I spent a lot of time watching what was going on in the trial and subsequently in the briefs and so forth, and you worked amazingly hard. You and the people that worked with you, amazingly hard, and I just can't imagine anybody doing a better job than what you did. It was just spectacular.
Well, you're very, very kind. I had a phenomenal team. I had Tony Hunter, my son Richard Gray IV. We all worked hard. We all believed and still believe, frankly, in this cause. And it's just way too important to not give it 100% effort. We're working for, in my judgment at least, for millions of school kids who deserve better than what they have.
There were lots of different groups involved in it. There were, I think, 6 plaintiff groups, including the plaintiff interveners. And they had lots of different issues. You want to kind of give us just a quick overview of what those issues were, what was before the court?
Sure. There was 4 main groups that all had many ISDs involved, and all of those groups had adequacy, suitability, and the issue of whether or not the system was a statewide property tax as part of their claim. And 3 of the 4 had equity as part of their claim. The Calhoun County group, which by and large is the wealthy districts, they opposed us on equity. Then we had the 2 different intervener groups. You had the charter schools who intervened, claiming essentially all the same issues that we claimed as the Texas Taxpayer Group. And then you had the group called the Financial Efficiency Interveners, who were really looking at the system from just an overall efficiency point of view, not an equity point of view, but claiming that there was too much bureaucratic red tape, budget process was too difficult, teacher contracts were too cumbersome, things of that sort. And what ultimately happened at the trial court was that the interveners, the charter group and the financial efficiency interveners, lost at the trial court, and then the ISD plaintiffs, we won on all issues except for Calhoun County. They lost on the equity issue because they were opposing equity, and Judge Dietz found the system to be, in many regards, inequitable as well as inadequate and not suitable, and a statewide property tax. Unfortunately, when we get to the Supreme Court, although they acknowledge all the findings and acknowledge all the problems in the system, they essentially say this is the legislature's function, we're not going to get involved, and tell the legislature in 100 pages how bad it is and encourage the legislature to fix it, and I just hope the legislature does.
How does that technically work when you have people who are working together on so many issues, and then there is one issue in this case with Calhoun County and equity, where they in essence work with the state, in opposition? How does that technically work in court?
Well, it's exceedingly awkward. They literally, the Calhoun County group literally were opposed to us. The experts and witnesses we put up as equity experts and witnesses, they challenged, they went after tooth and nail. They brought their own expert to say the system was fair. And it makes for a difficult time to work together because you're working together on most issues, and yet you have another issue in which you're working diametrically opposite. And what it physically did was they would be on our side, all the school district side, for the bulk of the case, and then for the equity side of the case, they literally, they didn't physically get up and change seats, but they might as well have, because they were on the state side on equity.
The expert witness for the Calhoun County was Dr.
Cal Callison.
Cal Callison, who's from Eanes ISD, and one of the wealthy districts in the state, and here close to Austin. And he presented his information. He's very well spoken. But whenever you cross-examined him, and I give them lots of credit for this, and I think that we all ought to hold this up as an example of how we all should be supportive of one another. When you went around the state giving examples of two districts close by each other and about the differences in the tax rates and the differences in the funding levels, he responded that no, that wasn't efficient, it wasn't equitable.
He did. Dr. Callison, I did not know Dr. Callison prior to this litigation, and I met him for the first time when we took his deposition prior to trial, and then I had a chance to meet him again at trial, and I have a huge respect for him. He, when confronted with the facts, I don't think he was presented necessarily all the facts at the time he prepared his original testimony, but when confronted with the facts and the reality of what was literally happening on the ground in Texas, he readily admitted that that was not equitable, was not right, and was not the kind of system that he thought was appropriate for Texas. So I gave him kudos then, and I give him kudos now. He's an honest, good man who, when although he was called as an expert against equity, when confronted with the real facts, he admitted that the facts spoke volumes and we needed to reform the system.
That speaks well to the quality of a man when he's able to do that.
It does. I hold him in very, very high regard.
Historically, the groups that have been before the courts have always had school district names like Edgewood ISD, and then they'd list the others in that group, and it would become known as Edgewood ISD et al. And the Alvarado plaintiffs, which was actually your group in Edgewood 1, correct?
They were. I was one of the lead lawyers in Edgewood 1 for a group that intervened but had the exact same issues as the original group that started Edgewood 1. And we're quite happy that we prevailed in Edgewood 1 to start the system on a forward march towards equity. We haven't gotten there. The system is better than it was at the time of Edgewood 1, but we still have, in my opinion at least, need for vast improvement. But in this case, it was broadened beyond just school districts. This case had to do with kids, had to do with parents, and had to do with taxpayers. What we have found is that taxpayers throughout Texas may pay virtually the identical sum for public education within their district, but that translates into their children, some children having a huge advantage compared to other children suffering under a huge disadvantage when their parents are paying the exact same sum. So we tried to, in this case, broaden the claim to beyond to just the typical school district equity and school district adequacy, but look at what's actually happening to taxpayers out in Texas, because they're getting abused. I mean, the honest answer is they are paying way too much in property taxes, in my judgment. But even worse than that is when they pay large property taxes, their kids aren't getting the same bang for the buck. Two homeowners may pay $5,000 in property taxes or $10,000 in property taxes, but one of those is going to get their kids will get a whole lot more spent on them than somebody else right next door, and that's just not right.
Yeah, same tax rate but different results.
Hugely different results. I mean, in this case, for example, we looked at districts and we organized districts by ranks of top 5% wealthy versus 5% poor and so on. And if you look at the top 15% wealthiest districts compared to the bottom 15% wealthiest districts, what the evidence actually showed was that the poorest districts were taxing on average 9.6 cents more than their wealthiest counterparts, but getting over $3,000 per student less than their wealthiest counterparts. That translates into, $100,000 or more per classroom. That is literally, you would be paying more tax than your neighbor, yet your kids get $100,000 less spent on them per classroom than your neighbor's kids. That's the system we have today.
Well, did the ruling that came out of this, Justice Willett wrote the opinion, did he change the definition of what's equitable and what isn't equitable from what was adopted in Edgewood 1? Did he say that's no longer in place?
No, in fact, they reaffirmed it. They say that the standard is substantially equal revenue for substantially equal tax effort. But when you look at all the facts, I frankly and respectfully disagree with their interpretation. They focused more on ratios, 1.7 to 1.0 or 1.3 to 1.2, and ratios don't tell you the story. What tells you the story is actual dollars and cents that's available to school districts to educate kids. And when you have circumstances where poor districts are having to tax substantially higher than their wealthy counterparts and yet receive hugely less money for their effort, that's just not right, and at least not right in my opinion. And I think by the outcry that we have seen in Texas through editorial after editorial, through articles in things such as the Baptist Standard, groups that have organized pastors for Texas kids. This is not just a one or two school districts complaining. This is a system that is woefully broken.
One of the things that we're talking about is the first time that the state ever prevailed in school finance litigation was in Edgewood 4. And in that instance, they said it was marginally acceptable. They didn't say, you fixed it, you can go ahead and about your business, you've done it right. They said, we're going to accept it, but it's marginally acceptable. And at that time, the ratio was something like 1.07 in tax rate, and that was at $3,500, which was part of what the Supreme Court judged at that point. They used it for the general diffusion of knowledge. And so I've got a two-part question here. One is, how did this current ruling, does that mean that the current system is within a 1.07 ratio to get to the same amount of money? Is that what it took in order for it, because it was only marginally acceptable, is that what it took to be constitutional? And the second question I would like for you to go into is that $3,500, because you didn't do just equity, you also did an outstanding job on adequacy, and you presented an expert, Dr. Bruce Baker, who's from Rutgers University, who used that in order to come up with a general diffusion of knowledge. So can you kind of address those two areas?
Sure. We did present Dr. Baker, who is an outstanding witness, and he looked at the system as a whole and did some analysis and had the opinion that the system would, to provide a general diffusion of knowledge in today's world, you would need to have at least $6,500, $6,800. He then did the analysis that I thought was exceedingly telling. He took what the Supreme Court had said in their Edgewood 4 opinion, that it cost to provide a general diffusion of knowledge back at the time of Edgewood 4. And he extrapolated that number, and that was $3,500. And he extrapolated that forward based only on inflation, not taking into consideration all of the new tests and standards that are put in place on school districts, but just using the Edgewood 4 standards that in place at that time. Extrapolating that for inflation, it came up to $6,576 would be necessary to meet today the standards in place at the time of Edgewood 4. And then we presented the analysis that only a couple hundred districts can even get there today.
At maximum tax rates?
At maximum tax rates, no matter, in the poor districts, the 400 and some odd districts that were in our coalition, they had no chance to ever get there, could never get to the level it would take to meet the standards that were in place back in the 1980s, I think, or when Edgewood 4 was decided. Now,
what if they did away with the $1.17 cap? Because you said they couldn't get there, you're talking within a cap. Could these districts that were in your group, could they then raise taxes well above that and or some degree above that?
Well, yeah, you want to raise taxes to $5 or $6
It was that bad?
$10, it's huge, it's terrible. No, it is beyond comprehension how high you would have to raise taxes to get to the level that your wealthy districts could still get to at 98 cents or 89 cents. Now, on the ratio issue, at the time of Edgewood 4, there was right at a 1.07, I believe, was the ratio between what it would take the wealthy districts and the poorest districts on a top and bottom 15% look to get to the 3,500. Under the facts in this case, we blew right by that 1.7 no matter what.
1.07?
1.07, I mean, and the court, in Justice Willett's opinion, his own analysis showed it was about 1.4, and unfortunately, and we all make mistakes. I think their analysis, he got some of his exhibits confused and was not making an apples-to-apples comparison when he did his ratio to show that it was 1.4. And the real ratio is about 1.52 or 54 when you can do an apples-to-apples comparison.
Actually, 1.57, and I actually like to show you something. We did an analysis of it, of course. That's what we do here at the Equity Center. And we found that there were some errors in the way that they did it. And let me show you something real quick that you might find interesting. Mistakes happen. That's to be expected. But when they happen in a court case of such magnitude that it impacts the futures of millions upon millions of kids over generations, then it's problematic. So I want to show you something that's happened in this latest court case. This is the ruling in the Texas Taxpayer and Student Fairness Coalition litigation that we've just finished up here in Texas. First point, all 9 justices agreed with this ruling, and therefore the things that are in it. And one of the basic frameworks for deciding this issue has not changed since Edgewood won. That's very important. Basic framework not changed since Edgewood won. That's the first litigation that we held. And what it is, they held that districts must have, not optional, not should have, but must have substantially equal access to similar revenues per pupil at similar levels of tax effort. And that's on page 69 of this particular opinion. This is also in the opinion. Now, this is the second part of a paragraph. The first part has nearly an identical sentence, and it has to do with Lisa Dawn Fisher's data. She represented the state. This part has to do with my response to that, or what they put in to balance with that. And I want to call your attention to a couple of things here. First of all, what we're measuring is M&O revenue per student in weighted ADA, weighted students, for the top and bottom, and notice this, 5% of districts. Now, I want you to look at this number here. That's the average for the top 5%. This is the average for the bottom 5%. And here's the ratio, 1.42, which they said that's good enough. That's similar revenue, a 42% differentiation. But let's go back. You see it right there? 81.46. That's WADA. That's not in 5% of districts. That's in districts with 5% of the WADA. You notice that there's 111 districts in this group. There's your 42% differentiation. Well, let's go to the exhibit that is the correct one. Districts, 5% of districts. You notice there's 51. We have a little over 1,000 districts. Look at that number. Much bigger number. Look at this differentiation. Much larger differentiation. This is what it should have been. $9,021. This changed not a lot, but it did change some, and the ratio is 1.57, a 57% differentiation, not the 1.4 that they said this was just a little more than. That's pretty substantial. So the question is 57% more similar? Let's take it and look at it. This is the top 5% of districts. This is the bottom 5% of districts. And here's the gap per weighted student, which is the way we count students for school finance purposes. Now, in that bottom 5% of districts, it so happens that for 22 children, their average little over 30 weighted students in this particular group. So if you take the gap per weighted student by the number of weighted students in a classroom, typical elementary classroom of 22 kids, that's what you get. That is what that differentiation provides per classroom, $98,246. Now, something that they didn't even bring into it, but has to be considered because you have to consider tax effort. Those people on the bottom taxed 11.3 cents higher to pull their kids within $100,000 per classroom. I don't know what definition of similar, $100,000 and having to tax 11.3 cents higher to get there. I don't know what that is. I think you could argue that that's not similar, and the tax rate's not similar. Now, someone may say, well, what if they had ruled anyway that it's going to be 1.4 and they just didn't use that when they saw that it was 57%. Well, let's just go with that. 40% more. We normally have around $6,000 per weighted student in the state. That's 40%, it's a $2,400 gap. $2,400 gap. 30 watt in the classroom times 2,400, that's $72,000 per classroom, and still at 11.3 higher tax rate. If you bend over backwards and take the worst possible scenario and ignore the evidence in the record, you have to still come up with an allowance of $72,000 per typical elementary classroom at an 11.3 cent higher tax rate. I don't think very many courts would consider that to be similar. You know, one of the questions that always comes up is about recapture. And I've read with some interest when people refer to this system as the Robin Hood system. And of course, recapture is just a small part of a much larger, much more complex system. But that's one of the things that catches people's attention. Was there anything in this ruling? You know, historically, the courts have always supported that, said it's constitutional, and in West Orange Co. 2, they said it was necessary.
Right.
Was there anything in any part of this ruling or in any of the two other rulings that were submitted secondarily, is there anything in there that talked about recapture maybe not being constitutional or not being necessary?
No, they do not in any form or fashion condemn recapture, say recapture needs to be done away with. And the reality is, although the system, in my judgment, is hopelessly broken, if you didn't have recapture, it would be beyond repair under its current format. So no, nobody on this court would took any shots at recapture whatsoever.
With the illustration I just showed you about the $100,000 difference per classroom, that's with recapture in place. I can only imagine what it would be without recapture.
Oh, it would be astronomical. It would be, I mean, without recapture, frankly, you'd have, in my judgment, you'd have a bunch of school districts that literally could not function.
Taxpayers. We know from the data that was presented at the trial that taxpayers in the lower funded districts are taxing at significantly higher levels, like 10 cents higher, and actually to get less. Was there anything in this ruling that gave them some relief?
No. Well, that's the honest answer, is no. The only way you're going to get relief for taxpayers is if you truly do get to substantially equal revenue for substantially equal tax effort. But as long as you are having the existing system stay in place, you're going to have taxpayers in some districts paying way too much and their kids getting way too little compared to taxpayers living in wealthier neighbors who pay a lot less than the other taxpayer and get a lot more spent on their kids. And in that situation, you end up with the taxpayer themselves are getting taken advantage of, and the kids are getting taken advantage of. I mean, the system is letting down both the kids and the taxpayers, and is putting the burden on your districts that are having to operate in this system, putting a hopeless burden on them to meet ever-increasing standards with less revenue.
So, bottom line, a defeat in a battle, pretty tough to take, but not the end of the war. We still have the legislature who was going to be the one that had to make the changes anyway,
right,
regardless of what they ruled. And so the kids still have a chance of coming out on top on this.
Kids have a chance of still coming out on top. I mean, the litigation, there's no question it was ultimately turned out to be a terrible defeat, and one that is probably the hardest loss that I've ever had in my career. Probably because it's this case is probably the most important one I've ever had in my career. But at the end of the day, even if we had won at the Supreme Court level, it would have had to go back to the legislature to be fixed. And so the battle is not over. The battle has just shifted to the legislature, and we need as many parents and as many educators and as many people that are concerned about the future of Texas as we can to get involved and to have the legislature do the right thing.
Thank you very much for giving us your time and talking about this case.
That's my pleasure. Thank you.
For the latest news and information, make sure you follow us on Twitter, like us on Facebook, check out our videos on YouTube, or find us on our website, equitycenter.org.